Hi, my name is Ashley Mize, and this is my presentation timeline on bilingual and ESL educational policies from 1965 until 2015. It started in the 1960s. In 1965, the Elementary and Secondary Education Act, known as ESA, had become a public law. President LBJ Lyndon B. Johnson had provided federal funds through financial support to help low-income students. The initiation of educational programs had included such as Title I and bilingual public education. Later, in 1965, the ESA had its first amendment and included a public law. It had furthered the Title I as a provision of ESA. The program itself, for low-income families and children who have special needs, would be observed that without funding could not be properly supported. Later, in 1968, the first Bilingual Educational Act had been published as a public law. This ESA amendment had a proposed bill to provide services to English language learners to include Title VII. Reauthorizations of the Act occurred in 1974, 1978, 1984, 1988, and 1993 to 1994. Later, in 1969, HB House Bill 103 had been published. Texas Representative Carlos Truon and Senator Joe Bernal had created together the first bilingual educational bill in Texas. It was used to repeal the English-only statute. House Bill 103, which became the Texas Bilingual Education Act of 1969. Later, in the 1970s and 1970, Identification of Discrimination and Denial of Services on Basis of National Origin had been published. This document was used in litigation to secure better education services for language minority students. It influenced education of English learners nationwide. Later, in 1971, Cicineros versus Corpus Christi Independent School District had its first case. Mexican American students were grouped together with African American students to comply with the desegregation. However, the court had found in favor of the plaintiffs and ordered them to be integrated back into the schools of the groups of students, including white, black, and Mexican, all together in the public school. Then in 1971, the U.S. Court of Appeals for the Fifth Circuit had a case. Judge Justice ordered that the Texas Education Agency to assume responsibility for desegregating of all public schools. This applied to Texas schools and institutions affected over 2.5 million children and was considered the largest desegregation orders in legal history. Then in 1972, the Texas Association for Bilingual Education had been founded. It was a group in the United States founded in San Antonio, Texas, as an advocacy group for the rights of language minority children, particularly Spanish-speaking students. Then in 1973, the Bilingual Education and Training Act, SB 121, Governor Dolph Briscoe of Texas signed a law abolishing HB 103, Texas English-only teaching requirements that had punished speakers for not speaking English. The bilingual programs to all students with 20 or more limited English-speaking students in the same grade had been passed. Then in 1974, the Bilingual Education Act had another amendment as a public law. This amendment in 1974, the Supreme Court had found that the ruling of Lau versus Nichols impacted the Bilingual Education Act, and with the amendment, it had provided new information to support bilingual education. Then in 1975, the National Association for Bilingual Education had been established. NABE is an American advocacy group that provides teacher training, educational leadership, and lobbying efforts on behalf of legislation regarding individuals learning English as a second language, whether it be Spanish or any other language. They oppose structured English immersion and favor bilingual and multilingual education. Then in 1978, there was another reauthorization of ESA had been published as a public law, incorporated changes that helped in the creation of early exit transitional bilingual education. It had prohibited federal funds usage of bilingual education. Then in 1979, the Bilingual Education Student Organization, or BESO, had been established. It is affiliated with the Texas Association for Bilingual Education, or TABE, and they are a group of individual student chapters located across various universities in Texas. For one example is we have one here at Texas State University. In the 1980s, in 1981, Castaneda versus Picard had a case. The Fifth Court of Appeals had decided that the mandated 3 steps to develop quality bilingual education programs needed to include 1. That program implementation must be based on sound research, 2. With adequate resources, and 3. Opportunities for students to have access to the full curriculum. Later, in 1981, the U.S. versus State of Texas had a case with Judge Justice had ordered Texas to offer a bilingual education for Mexican American students, allowing them optional dual language instruction in kindergarten to grade 12. Bilingual education was mandated through elementary schools, bilingual or ESL for middle schools, and ESL for high schools. Later in the 1980s, in 1982, Plyler versus Doe had a case. The court reasoned undocumented parents and their children, although they may not be citizens of the U.S. or from Texas, they are people, and in any ordinary sense of the term, they should be and are afforded the 14th Amendment protections. Later, in 1984, the Elementary and Secondary Education Act had another amendment. This ESA amendment broke from the compensatory model of bilingual education, the early exit, to take an enrichment approach and allocated special funding to implement such programs, late exit. This had made ESL an alternative program to serve the ELs. Then in 1988, Hawkins Stafford Elementary and Secondary School Improvement. This act had been published as a public law. The reauthorized act had included changes from the previous reauthorizations of ESA that reflect the current emphasis on the diversity of LEP or EL students and approaches to their education. Then in the 1990s, from 1993 to 1994, H.R. 3229, Bilingual Education Act, had been introduced on October 6, 1993, with the new grant categories set up preference to programs promoting bilingualism and took into account indigenous languages. It was later referred to the Subcommittee on Elementary, Secondary, and Vocational Education on October 22, 1993. This act had never actually been officiated into a law. In 1994, the Improving America's Schools Act, ISA, had become a public law. President Bill Clinton had signed this, renaming the ESEA legislation to ISA. This version of the legislation allows the creation and development of dual language programs. Then in 1996, TExES, the Chapter 89 adaptations for special populations, 21 Text Reg 5690 had been established. The provisions of this Chapter 89 had adopted and became effective September 1st of 1996. The last provisions for ESL bilingual students were adopted in May 2012, supporting ELBS, dual language bilingual education, and ESL programs. And to further note, something that I did not include on this presentation, the last update to this specific chapter had been made in March 2021. Then in the 2000s, in 2001, dual language immersion law had been established. A dual language immersion program should be designed to produce students with a demonstrated mastery in both English and one other language of the required curriculum under Section 28.002. Later, in 2002, the No Child Left Behind Act had been published as a public law. President George W. Bush had signed this law into effect, replacing the No Child Left Behind Act of 2001, which also replaced the ESCA of 1969. The NCLB had replaced the Title VII, the Bilingual Education Act, with Title III, English Language Acquisition, Language Enrichment, and the Academic Achievement Act. It redefines the federal role in K-12 education and helps close the achievement gap between the disadvantaged and minority students, including their peers. Then in the 2010s, in 2010, the United States had a case against the state of Texas. The Fifth Circuit of Appeals had found that their determination whether the state or individual districts, which have yet to be brought into the lawsuit, should be held liable for the dismissal performance of secondary ELLs, and it had been considered as an EEOA violation. The decisions were to reverse the injunction and remand the case as the direct court ruled that Texas had continued to fail the EL students as evidenced by disparate academic achievement. Later, in 2015, the Every Student Succeeds Act, or ESSA, had been established. President Obama signed ESSA, replacing the NCLB Act. One of the key provisions of ESSA was that it required a state-developed system to identify and provide support to low-performing schools. For one example of this, Title I schools, including the achievement discrepancies in the subgroups such as white, Black, Hispanic, or Latino that had been represented in these schools. And that concludes my presentation. Thank you all so much for your time.